bill requests. First person I'm going to call on is Representative Croft.
Thank you, Mr. Chairman. The bill I'm requesting is RS 1106. It's a bill authorizing a citation or notice to appear for unlawful possession of marijuana and defining the complaint in the Kansas Code of Criminal Procedures to include such citation or notice to appear. And this was specifically requested by the Sheriff of Johnson County because there seems to be a difference for the sheriff versus the local. So.
Any questions, committee? Any objection? If not, we will get RS 1106 introduced. Thank you,
Mr. Chair.
Next from the committee, I have Representative Humphreys.
Thank you, Mr. Chairman. I would like to request RS 0719. And it has to do with, it's from a constituent of mine. It has to do with changing a few things about the autopsy law and coroners.
Any questions? Any objection? We will introduce that one. Back to Representative Humphreys.
This one would be RS number 1094. And it has to do with looking at attachment when in our SINC code, our Child in Need of Care code, when a judge is determining permanency decisions.
Any questions? Any objection? We will get that one introduced.
Very good.
Back to you again.
Thank you. And the last one is RS 1090, and it is a UIM transparency and insurance. You've seen it before, and it's requested by the KTLA.
Any questions? Objection? We will get that one introduced.
Thank you.
Anyone else on the committee with bill requests? Representative Hobson.
Thank you, Mr. Chairman. I'd like to request the RS number is RS 1091, and pretty much it was a bill, was Senate Bill 55 of last year, which is a Uniform Partition of Heirs Property Act. This bill would assist in the partition of property, which is owned as tenants in common, or in some portions was inherited, or by the co-tenants who are relatives. So that's what I wanted to request.
Any questions, committee?
Yes, Mr. Chairman, I may have missed it, but is this request on behalf of the representative or some other person or organization?
Oh, on behalf of myself.
Any other questions? Any objection? We will get that one introduced. Anyone else on the committee? Representative Curtis.
Thank you, Mr. Chairman. I'd like to request the introduction of RS number 1054 regarding worker comp mental injuries.
Any questions? And I apologize for not calling on you sooner. You are on my list. No questions. Any objection? We'll get that one introduced. Any other bill requests from committee members? Okay, now we will move.
Representative Patton.
Yes.
Sorry, I don't have normally I have a more subtle way of doing this when we're all sitting together, but I'm just wanting to check if Representative Burris has something that he wants to request.
Representative Burris, do you have anything you'd like to request?
Mr. Chairman, can you hear me?
Barely.
Sorry, I'm a little.
There we go.
I have a cold. When the temperature drops drastically, I seem to get a cold every time that happens.
Okay, we can now hear you.
Mr. Chairman, I do apologize because I hadn't had a chance to talk with you about this, but I was hoping to request for introduction RS 100. Excuse me, RS 1001, and it has to do with firearms rights. It's actually I guess a retread of SB 121 from 2017.
Okay, committee questions?
Mr. Chair, may I inquire, is the representative offering this legislation on his own behalf or on behalf of others?
My own behalf.
Any other questions? Any objection? We will get that one introduced. Anyone else on the committee? Or anyone else Natalie knows on the committee that may have a bill? Okay, let's see. So here in person, we have Jeff Wagaman with, I think, well, we'll see how many.
Good afternoon, Mr. Chairman and members of the committee. I'm Jeff Wagaman from Steve Kearney and Associates, representing the Kansas District Attorneys Association. We would respectfully request you introduce RS 1095, the Harris fix, redefining the term weapon and knife.
Any questions, committee? Any objection? We will get that one introduced. Thank you. Let's see, online.
I'm sorry, Mr. Chairman. I think that Jeff might be forgetting one.
Thank you, Natalie. Jeff Wagaman again. Yes, we have a second one, 21 RS 0935, an act concerning crimes, punishment, civil procedure relating to the abuse of a child, increasing criminal penalties.
Okay. Any questions? Any objections? We'll get that one introduced.
Thank you, Natalie.
Okay, online we have Rick Bailey.
Good afternoon, Mr. Chairman, members of the committee. I'm Rick Bailey, and with Christy Fisher, the Executive Director of the Wichita Animal Action League, we would like to request the committee introduce RS 0822, Bowie's Law, an act concerning crimes, punishment, criminal procedure. It's an amendment to the cruelty to animals statute, adding a definition of torturing.
Any questions, committee? Any objection? Not see any. We'll get that one introduced. Thanks for joining us, Rick.
Thank you.
Next, Lisa Veda.
Good afternoon, Mr. Chairman and members of the committee. My name is Lisa Veda, and I'm here to request the committee introduce RS 0865, an act concerning crimes, punishment, and criminal procedure relating to controlled substances, immunity from prosecution for seeking medical assistance. Thank you.
Any questions? Objection? We'll get that one introduced. I have one on behalf of bids. This deals with their statutory hourly rate, and the RS number is 1093. Any questions? We'll get that one introduced. Anybody else with bill requests? Your last shot, unless Natalie has us open it back up at the end when she thinks of something else, but hopefully that's your last shot. Okay, we will move on. Thank you, everybody. We've got a couple here bill hearings today. The first one is 2153. I'll open that hearing and have Natalie share with us some details about this bill.
Thank you, Mr. Chairman. House Bill 2153 would increase the criminal penalties for mistreatment of a dependent adult who is a resident of an adult care home. So the bill amends KSA 2154-17 to provide that mistreatment of a dependent adult or an elder person that results in physical injury, unreasonable confinement, or unreasonable punishment would be a severity level 2 person felony when the victim is a dependent adult who is a resident of an adult care home during the commission of the offense. And then similarly, mistreatment of a dependent adult that results in a taking of property or financial resources would be a severity level 5 person felony when that victim is a dependent adult who's a resident of an adult care home during the commission of the offense. And I can take any questions.
Any questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. Ms. Scott, I seem to recall this bill from somewhere. Have we seen it before, and what fate did it meet?
Mr. Chairman, you haven't seen this bill. You guys did do some stuff with mistreatment of a dependent adult. I think that was a couple of years ago. I can't remember, but I'm sure the Attorney General's office will remind us, but this is a new one.
Thank you for correcting my bad recollection. Thank you, Mr. Chair.
Any other questions for Natalie? Representative Heiberger.
Now, this may be for one of the conferees, but I'm curious about the proportionality of a level 2. Can you cite a couple other things that we rank as level 2 felonies? Could you hear me?
Yes, sorry. Let me, I'm trying to find something here.
I can save it for a conferee if you'd like.
There are, so second degree murder in some instances, the reckless circumstance, that's a severity level 2. There are certainly some like higher level sex offenses, but I can find some statutory citations for those for you.
Thank you.
Representative Jennings.
Thank you, Mr. Chairman. It's been my experience that Scott Schultz's shop is capable and willing to provide that comparison for that kind of parity of sentencing and you know, what be in that range. Probably has it at their fingertips. Maybe our research folks could request that from him.
Good. Anyone else with a question for Natalie? If not, we will begin with proponents. And on behalf of the Attorney General's office, we have Steve Carr.
Mr. Chair and fellow members, first of all, Mr. Chair, can you hear me?
I can. Please proceed. Thank you.
Thank you. First of all, let me say thank you for allowing me to testify again in front of this committee. I've testified several times on these matters. As Mr. Carmichael pointed out, we have been in front of you several times over the last several years about issues related to elder and dependent adult abuse, and appreciate every time you allow us to come talk to you. This bill is rather simple in terms of what it does. It's probably a little more complicated in why it is important to you, and I want to address that. So in my written testimony, I talked about the mechanics of it. I don't know that I really stressed as much as to why this is so important in terms of the power disparity. So that's really what we're talking about, is recognizing the power disparity when someone is in an adult care home. So essentially, oftentimes, almost everything needs to be provided for them, and they do not get to direct most of the decisions they have to make. And that's extremely important. That differs from someone who might be being cared for in their home or has family members that are caring for them that can speak on their behalf. That is different when an individual is in the care home. I've spoken to you many times about my mother. She suffers from dementia. She has never, thank goodness, never been abused. But one of the things that I have learned through this is that she loses the ability to make decisions on her own and control her destiny, control where she goes, how she does things, what she gets to do. And that will decrease over time. She currently still lives in independent living, but that's because my dad is able to assist her. But many people who suffer from dementia or Alzheimer's are not able to live on their own and have to live in an adult care home. And so what that means is someone may have to feed them. They may not even get to choose what food they want to eat or like to eat. They may have to have their diapers changed. They may not be able to control their bowel movements, those types of things. That's what we're talking about, is literally all of their daily activities having to be provided by someone else. you can obviously understand the vulnerability that puts someone in that position. I think in the neutral testimony, it talked about COVID-19. This is even more relevant today in light of COVID-19 because we even have less family members, even have less contact with individuals who are in adult care homes. So even being able to observe their family member is extremely difficult. I told you about my mother. She just recently broke her hip and had to be in skilled nursing for several weeks. For the first 2 weeks, no one was allowed to see her from the family. Now, they took excellent care of her, but if someone was abusing her, it's not as if we would have been there to be able to see the bruises or recognize that abuse was occurring or even see changes in behavior. The other important fact to keep in mind, there's a well-cited statistic out there. I can give you the specific source. It's actually out of a medical magazine or journal, medical journal. But the statistic says that individuals who are elderly, individuals who are abused have a 300% higher risk of death than those who are not abused. That's important to keep in mind. I know some examples in the neutral testimony were given about a door being left open too long or not being able to get a piece of pie. That's not what we're talking about here. I've never seen a case like that filed, to my knowledge. I've never seen a case like that come across my desk, and I see almost all the complaints of abuse, neglect, and exploitation that end up being law enforcement referrals. I see those come through the A&E unit, and I have not seen those types of matters being prosecuted. An example that comes from our Medicaid fraud division is an individual, a nurse, who is caring for an individual in a facility and removes their fentanyl patch, causing them significant pain, and did it, I believe, multiple times so that they could actually obtain the fentanyl for themselves. That is clearly not a training issue. It might be an issue of addiction, but it is certainly not a training issue that leads to that type of abuse. And it caused extreme pain, which under our case law says extreme pain can be sufficient for quote unquote injury. For all of these reasons, it's appropriate in our belief to have the penalty be what it is. I know there's some examples given of level 2 felonies in the neutral testimony. I'd give you one. We have level 2 severity felony in securities fraud. It's over $1 million. If you steal over $1 million in securities fraud, it is a level 2 felony. There are some felonies related to lower levels of homicide. There are some sex offenses, but I believe that this felony is just as significant and frankly has just as significant outcomes for the victims of these crimes and is why we're asking for it to be more severe. One last thing, just to speak as to the neutral testimony, and is there was an indication in the neutral testimony that KDADS covers all individuals in nursing homes, and they substantiate on those individuals. As you have seen in our annual A&E report, that is not exactly the case. KDADS actually does not keep a registry as required under 39 Chapter 14, and they do not substantiate on anyone who is not a CNA. So if they're a nurse, a doctor, a janitor, a manager of the facility, they will not substantiate on those individuals. So to the extent that there appears that there might be some civil recourse, I would indicate to you that's not wholly accurate. And I'll stand for any questions.
We have Representative Carmichael.
Thank you, Mr. Chairman. I note that you have observed some facts or assertions from the neutral testimony. I assume you're talking about the testimony from the nursing home industry. Is that what you're talking about?
No, I believe it was from Brian Cox from the criminal defense lawyers. Maybe I'm incorrect, but I believe
Okay,
it's.
well, I have to confess to you, you don't have a hot panel today. I just got off the highway and started reading the testimony, so I'm not 100% up to speed on that, and I apologize. But suffice to say, you're of the opinion that concerns, and I was reading, ks.gov. I was reading examples of CRNAs being prosecuted, CNAs being prosecuted. You made reference to people not getting their pie, but what you've seen in that testimony is not consistent, I take it, with what your own experience has been. Would that be fair?
That is fair. I think most of the things that I'm speaking of would be, for instance, on the like on the pie example. I don't think he was in fairness, I don't think Brian was saying that that had been prosecuted. I think what he was saying is that could fall into this statute. But examples I have seen over the years are someone who would, for instance, might take feces and put it on an individual because they're upset that they have defecated on themselves again, and they get upset and they wipe it on them, or they slap them as a result of that, or they grab their arms to the point and shake them and causing bruises. That's the type of things that I'm referring to anyway when I refer to punishment.
And quite frankly, that's where I was going with my questions regarding your testimony, because I think all of us would recognize that behavior like that ought to be criminal, and I think that's the position of the Attorney General. Not only it ought to be criminal, but it, in appropriate circumstances, should be a serious person felony. Can we agree on that? Well, the reason that I ask is the committee saw testimony just last week that if it became law, would give adult care facilities immunity from fines or penalties imposed by KDADs or the Department of Health and Environment, I think probably more specifically, who surveys nursing homes. Would it be of assistance to you in your efforts to protect these elders who are isolated from their families and outside influences or outside observers? Would it be of assistance to you in protecting these vulnerable people if we had a law that said that nursing homes are immune from penalties or fines imposed by KDHE and others in the context of COVID, unless there was a showing of gross or wanton negligence? Would that help you in your job to give these folks immunity, or is this a shared responsibility between the law enforcement community and the regulators? Does that make sense to you, sir?
Yes, I'm not sure if I'm in a position to answer that question. What I will say is, if you're talking whether giving them civil immunity would affect our ability to prosecute them criminally, my answer would be no. I do not believe that would affect our ability to do our job or make it any less or more easy to do our job. That I can speak to. Outside of that, I'm not sure that I'm.
Yeah, my question was imprecise, and I apologize for that.
No.
I'm talking about granting the nursing home industry immunity from enforcement actions brought by KDHE or Kansas Department for Age and Disability Services. Would the Attorney General want to see us make these facilities immune from actions by the regulators who are supposed to be protecting these vulnerable adults?
I see what you're asking. My answer to that is I don't know the position of the Attorney General on that bill particularly, and am not in a position to answer. I appreciate you asking it, but I can't answer that.
Well, I'm just trying to help protect these folks, and I know you are too. So thank you, Mr. Chairman.
Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here today. Now, I had a mother who was with dementia, who was in a nursing home for 9 years. I certainly understand the concerns you're raising, but do you have any evidence that would show that raising the sentences on these crimes would decrease their frequency?
No, I don't have any specifically. I think that's always difficult to obtain. I don't. One would be.
And one more, with the chairman's permission. You gave the example of a CNA spreading feces on a patient, and that's really awful and disgusting. Should that be a level 2 felony? Well, my question is, would that be a violation of 5417 in your eyes?
It very well could be, absolutely. Again, everything is fact specific, especially in these cases, but absolutely that's one that could rise to that level.
And is that should that be a level 2 felony?
I think it should.
Okay, thank you for your testimony.
And I can speak to as why I think that's the reason.
Sure, go ahead.
I think the reality is that in many of these situations, you have to keep in mind the difference between being in a home and being in a facility. As you well know, if someone is to the stage of, let's say, severe Alzheimer's or dementia, to the extent that they're not able to control their bowels, they are not able to even recognize that they are a victim or have the capability to even report that they're a victim. And it's not, and that vulnerability is what is exploited by the individuals who are committing these crimes. We can talk about the definition of, I think there's some comments made about the mens rea required, and I'm glad to talk about that. But the reality is they are exploiting the vulnerability. They would not do that to an individual who had the ability to defend themselves or be able to speak out, right? But they do it because of that vulnerability. And yes, I believe that does warrant being a level 2 offense. They can't even tell anybody, hey, this person just rubbed feces on my face.
Senator Jennings.
Thanks, Mr. Chairman. I'm just looking at the sentencing grid here. Got two questions, if I might. So at the sentencing grid, it looks like severity level 5, no prior misdemeanor, no prior offense whatsoever, low range 31, top range 34 months, and severity level 2 is 109 to 123 months. So it's a pretty big jump in terms of time served, plus the severity level 5 is a border box. So there's a judicial discretion component that doesn't have to be overwhelmed by a departure request. Is that all pretty much right so far?
Yes.
Is there any special sentencing rule that exists that would convey to the court the ability to go to the top end and imprison on these kinds of crimes in homes that you're aware of?
No, I think it would just be the statutory factors related to departure, either a dispositional or durational.
Thanks. And then 215602 child abuse is the torturing, cruelly beating, shaking that results in serious bodily harm. Children typically are seen as operating at a disability by virtue of their age. We're talking children as young as an infant to as old as 17 years, 364 days. I think in the words you used, people exploit vulnerabilities. I think that argument fits with children. They're at a disability, as I said. That's a severity level 5 felony. So does the Attorney General not think we should protect children as much as we do elders?
First of all, I can't speak on behalf of, I guess what I would say is that whether another crime deserves to also be a level 2, that may be a very good discussion, whether child abuse should be a level 2. I personally would agree to that, but I'm not stating that that's the bill we're here on today. What I'm saying is for this crime, for these situations, this is an appropriate sentence.
Eddie, any other questions? Let's see any. Thank you for being here today.
Thank you.
Written proponent testimony we have from Kansas Advocates for Better Care. Is there anyone else here today as a proponent? Not see any. We actually, committee, have 2 neutral conferees, one on your agenda, and then we're adding Rachel Monger. That was on our end. We failed to list her, and her testimony has been emailed out, so you have it. First one is Brian Cox, and Brian is on WebEx.
Thank you, Chairman. Just make sure that everybody can hear me all right now.
We can, yes.
Thank you. I thank the committee for the opportunity to testify here today, and we've already had a little bit of discussion about the content of my testimony, and I'll address that shortly. One of the representatives asked about the comparable offenses. Looking into a few of the things that I've looked over, I do know that the Kansas Sentencing Commission has included those comparable that comparability analysis already in their written submissions. It's on the last 2 pages. I think most of the other offenses that are categorized as level 2 have already been mentioned, so I don't want to go over that too much, but they are in there if anybody is looking for that. My testimony here today, first of all, I want to note that as everybody here I think does, I support the objective of the proponents of this bill in protecting the elderly in adult care facilities. My own grandparents spent time in those sorts of facilities before they passed away. It is very important to protect the vulnerable and elderly in our society. The problem with this bill that I see is that I don't think that it's going to be effective to do so, and I think that it has some pretty significant negative side effects. As far as the effectiveness goes, if we look at the definition of this offense, and I know that my examples there, as Mr. Kerr noted, they're not examples of actual cases that have been brought, but looking at the language and considering how somebody that's potentially charged with something like this would defend it, those are examples of conduct that I don't think would fall outside of the definition of this bill. And so when I think the legislature goes to criminalize certain conduct, it's critical, at least from my perspective, that what you're aiming at trying to prohibit or trying to punish be pretty clearly defined, especially when it is something so egregious as the things that we're talking about today. So those examples of the pie, that again, that is an extreme example, but I think that it fairly could fall within the language of this bill precisely because, well, the language of this offense, because the language of the offense is so broad. It just talks about unreasonableness of the confinement or the punishment. Bearing in mind that a lot of these adult care facilities, they are memory care homes where somebody with dementia or Alzheimer's, my own grandmother had that, they do confine people. And you're going to play, if this were to pass, even today with the way that the offense is defined now, I think that it places those home care workers in a very difficult position in some areas where there could be a lack of clarity about just what is unreasonable or not. In order to resolve some of these problems that I see with the bill, I have suggested a few changes. I think adding a mens rea element to require that the person actually have an intent to cause some form of harm, be that emotional, financial, or physical harm, would resolve a lot of the problems, that would raise the mens rea and would fairly target the conduct we're concerned about. In addition to that, changing the standard for that confinement or the punishment, I think could resolve many issues. And providing a safe harbor that if somebody's acting in concert with their training, I think would also be a very important change for those healthcare workers. Overall, though, well, let me get to what I've kind of learned today that the Attorney General's office is really after, and that's the vulnerability and the inability of those victims to self-identify themselves as a victim to report the conduct. I don't think that increasing the severity level, particularly to a level 2 for this conduct, is going to do anything to resolve that. As I believe Representative Carmichael was already making the point about, removing liability for nursing homes If we want somebody to report this conduct and to stop it, I think the better way to do that would be to look at who is able to report that conduct, other workers, management of these adult care homes, and incentivize them to report it rather than simply applying a little bit blunt solution to the problem of elevating the severity level so severely. The last thing I would point out is that I have suggested adjusting the change in severity level. Right now, it is a border box finding. I will say that being in a fiduciary position, or a position where you are entrusted with the care of another or their finances, is absolutely something that is commonly cited as a criteria for an upward departure. I think that with that in mind, that this is already coming into play in those sorts of situations. If the committee is concerned about it being a border box, a single level increase in the severity level would render it a presumptive prison case for even a person with no criminal history whatsoever. And I think that that could, if the committee needs or wants a severity level increase, meet those objectives. And I would be happy to stand for questions as well.
Questions, committee? Do not see any. We will move on to our next neutral conferee, Rachel Monger. Rachel's also online.
Thank you very much, Mr. Chairman. Can you hear me?
I can, yes.
Okay, perfect. I am Rachel Monger with Leading Age Kansas, and we are the state association for nonprofit aging care providers. And we are submitting neutral testimony on the bill today because we are not interested in standing in the way of this bill. We in general support enhanced penalties for any type of mistreatment of a dependent adult. And we've actually worked over many years in conjunction with the Attorney General's office to extend and expand the definitions of mistreatment, as well as increasing prosecutions and penalties. The reason why we're doing neutral testimony is because we're still not quite clear on why adult care home residents are being singled out from all other vulnerable adults and their care settings. So there's no research we have encountered that shows abuse is more likely or more severe in an adult care home than in other settings such as state hospitals, group homes, community-based settings, or in-home care situations. We think that the public and investigators tend to hear more about abuse incidents in adult care homes, not because it occurs more frequently, but because we have systems at work to uncover abuse and get it reported, investigated, and prosecuted. If you talk to any adult care home operator, they can give you details on the strict training requirements, strict oversight and reporting protocols, and the severe penalties for failing to detect or report abuse incidents. And we even have an Office of the State Long-Term Care Ombudsman who's there to advocate for people who are vulnerable to abuse. And in case you didn't know, this is far stricter than any other care setting for vulnerable adults in the state. And we've heard from disability advocates for many times over many years about the abuse rates for people with disabilities and how much in the dark that tends to be. So we really think that when you look at the mistreatment of a dependent adult statute, the definition of a dependent adult includes people who live in a variety of care settings that are serving people that tend to be just as vulnerable as those in adult care homes. And those additional settings include medical care facilities, community or residential facilities for people with intellectual or developmental disabilities, community service programs and services for people with intellectual or developmental disabilities, state psychiatric hospitals, and state institutions for people with intellectual disabilities. We are just submitting testimony today to point out that if penalties are to increase for people experiencing abuse in institutional settings, we believe that those enhanced penalties should cover all vulnerable adults in all care settings in the state. Thank you very much, Mr. Chair.
We have at least a couple questions. Representative Carmichael. We will come back to Representative Carmichael. Representative Samsel.
Thank you, Mr. Chair. I'm not sure I've got, excuse me, the right person for this question, but in doing my homework and trying to get up to speed on this as well, I share, maybe I don't know the best way to say it, but why this particular issue is before us as opposed to the other ones. And I don't mean to bark at anybody for that, but I guess I'm wondering, I don't have a good understanding of criminal law. Are these typically set by the legislature and kind of a, not that it's ad hoc, but versus like a comprehensive scheme? Or I've got in the back of my mind that it seems like a lot of penalties and stuff are kind of on grids and scales and other things that kind of all mesh together in more of a comprehensive setting. So that's what that's a very probably basic rudimentary question, but I was trying to get a grasp on the bigger picture, if you will. Does that even make any sense?
It does. I'm not sure if anyone wants to answer. You might sit down with Chairman Jennings on that at some point in time.
I'll withdraw my question and I'll save that for a different day. Thank you.
Perfect. Hold on one second. Representative Carmichael got kicked out for a minute. Let's see. Representative Carmichael, are you back with us? There you are. Do you have a question?
Yes, I did. And I apologize, Ms. Monger, because I had a technological thing. My new $2,000 state computer just decided it's time to crash, so I didn't hear everything that you said. But my question for Ms. Monger is, today you tell us how important it is that we have regulatory oversight from organizations like KDHE to try to protect these vulnerable adults. And as a result of that oversight, my general impression is that your organization feels this law is not necessary. But I think just last week, nursing home industry was here saying that they wanted immunity from fines and penalties for violations of the law, which would endanger isolated adults who contract COVID in a long-term care facility. Can you explain to me why it is you don't want stronger penalties to protect these vulnerable adults, but at the same time you want to tie the regulators' hands behind their back when it comes to penalties and fines for abusing elders?
Thank you, Representative. We actually are not opposing the law or saying that it's unnecessary. We were actually saying that it should apply to all vulnerable adults in all institutional settings, not just adult care homes. And regarding House Bill 2126, from our perspective today, what we're talking about are, it actually doesn't have anything to do with KDHE or KDAD, it's criminal prosecutions, many times through the Attorney General's office, who we worked with quite a bit. And from our perspective, those two things are not related with our liability bill, which is limited to COVID-19 claims.
Well, Ms. Monger, with all due respect, I'm concerned about protecting elders in adult care facilities. And I think the two topics are very much related, because people who commit crimes against elderly people in nursing homes need to go to jail. And nursing homes that tolerate that type of behavior need to be closed down. I assume you don't disagree with that, do you?
Obviously, we believe that people should be punished for for violations of the mistreatment of a dependent adult statute.
But you don't believe that nursing homes should be fined or penalized by KDHE when they endanger elderly residents who contract COVID?
I think that we are asking for immunity that allows for gross negligent and willful misconduct, which I think probably any abuse claims would fall under. What we are asking for is that homes that are doing their best during this pandemic be protected from the very costly and very damaging litigation that has come up with the pandemic.
I guess we could argue that for another day. I'm just disappointed to learn that you apparently don't have much concern about injuries which arise out of negligence, but we can discuss that some other day. Thank you very much.
Other questions, committee? Okay, is there anyone here as an opponent? Not see any in person or online. We'll close the hearing on House Bill 2153. Committee, Mr. Cox did point this out, but Bob Gallimore texted me and did encourage everyone to look at page 4 and 5 of the bed impact statement that came from Sentencing Commission, because there is a, let me find it, a proportionality comparison on there. So you can take a look at that. And if we need more information in that area, let me know and we'll have Bob look into it. Now we'll open the hearing on House Bill 2226. Natalie, would you mind letting us know what this bill's about?
Thank you, Mr. Chairman. House Bill 2226 requires certain criminal convictions to be expunged from an offender's record automatically. Section 1 amends KSA 124516. That's the expungement statute that relates to municipal offenses. It would require the prosecuting attorney in the convicting court to file a petition stating the information that's required for expungement. Those convictions and related arrest records would be automatically expunged by the convicting court after 3 years. No fee would be charged for filing that petition, and upon receiving the petition, the court would be required to order the conviction and the related arrest records expunged. Section 2 amends KSA 216614. That's the expungement statute for district court convictions. The changes would require convictions that would be eligible for expungement after 3 years to be automatically expunged. The county or district attorney in the convicting court would be required to file a petition stating that information that's required for expungement. No docket fee would be charged for filing that petition, and upon receiving the petition, the court would be required to order the conviction and arrest records expunged. I can take any questions.
Any questions? Not see any. We will move on to proponents. Committee, for both proponents and opponents, I'm going to let them all share with us, and then we'll do questions at the end, so we have enough time to get to everybody. So first up is Mark Dupree. Since you're the first one, you may have to press that button. There we go. Oh, it's already on.
All right.
You're good.
We're good? Okay, thank you, Mr. Chairman, and all of the committee and folks who are in person as well as online. I'm Mark Dupree, District Attorney of Wyandotte County, Kansas City, Kansas. And I am for this bill. I believe that it is something that is necessary to further justice and to prevent crime in the future, as well as to make our community safer. Since 2019, the Wyandotte County District Attorney's Office has had what's called an expungement fair. And an expungement fair is where we open the community college where individuals are able to come and sign up for an expungement. In 2019, alongside the Kansas Legal Aid here in the state of Kansas, as well as Kansas City, Kansas Community College, we sat down with nearly 200 individuals there in Wyandotte County who at some point had some type of conviction on their record. Over the last 2 years, we have continued to do that process and have had over 400 folks who have come to get their record expunged. What is the meaning and the purpose behind that? You have my written statement there, so I won't go into depth too much. But what's important to know is that by the age of 23, 1 in nearly 3 Americans have a criminal record and or some type of arrest on their record. A person with a crime on their record or an arrest on their record is 50% less likely to receive a job. Now that's a problem because in order to be a law-abiding citizen, most folks need some type of money. I think it goes without saying that it's important that we have individuals who are gainfully employed so that they can be law-abiding citizens. Just like we have systems in place when an individual commits a crime and they are given prison time, probation, and or parole. It's our guidelines that tells district attorneys that we need to make sure that they complete said probation, said prison time, or said parole. Once everything is completed, our office then files the proper documentations to make sure that they are then released from that probation sentence or released from that sentence. And it goes into the court record to make sure that we all know that they have, in fact, paid their debt to society. I think it's important to note that we're only talking about individuals who have paid their debt to society. 2019, when we first had this event, there was an elderly gentleman who came in. He was about 65 years old, him and his wife, and they sat down and they began to fill out all of the paperwork. And after they filled out the paperwork, one of my assistants was sitting there with them, helping them through the process. They had a lot of questions. How do we fill this out? Where is this from? How is this possible? They didn't know where to find the expungement paperwork. They didn't know what the filing fee for the expungement paperwork. And he did not know that it was even possible. This specific gentleman had had a criminal record for 30 years, and it fit the statute to allow him to get it expunged. Once we were finished filling out the paperwork, he and his wife, they stood up and they cried and they hugged the assistant district attorney that was there. And I asked him, why are you crying? His answer came from his wife. And his wife said, we didn't know that it was possible for it to be removed from his record. For 30 years, he has been telling his children that that part of his life was behind him. But they could go onto the internet, they could run his name and they could see it. But this gave him the opportunity to go ahead and clear that. I think it's important this bill gives us the ability, as those who have taken an oath, to make sure that not only do we make the community safer, but we do our part to prevent crime from happening. This gives individuals an opportunity, once they have paid their debt to society, to deal with the collateral consequences. And those consequences are often times impediments on jobs, impediments on homes, impediments on businesses, impediments on licenses to become barbers, to become drivers, all kinds of things. This simply gives them the ability, as we do when they serve their time, to file the appropriate documentation so that they then can move on with their life and be what we all expect and hope for them to be after they pay their debt to society, which are law-abiding citizens who are tax-paying citizens rather than tax burdens. Now, as DA, I must say that yes, it's more work on the assistant district attorneys and myself. However, this gives us the ability to do something proactive rather than reactive. Because if and when that person commits another crime, our office is going to have to file the paperwork. Our office is going to have to file the charges. Our office is going to have to talk to the victims. Our office is going to have to present the case. Our office is going to have to spend the tax dollars to convict this person. So, would I rather spend a little money and filing a few extra paperworks to prevent a potential crime from happening, or wait until they commit another crime and have to spend the same money, if not more, convicting them? I would choose prevention. By way of victims, it's important to note that any time that an individual files for an expungement, the district attorney's office, it's our obligation to notify the victims. We do that whether or not it is an automatic expungement or if it's a random expungement. Throughout the expungement fair, we did it. If individuals right now file for the expungement, we do the same thing. We notify the victims and we give them an opportunity to come and be heard. I will tell you that many of them do not, because they've moved past that. I think it's important that we make it automatic for individuals to automatically move on with their lives, because some of them do not have the funds, the time, or the knowledge, the know-how to get this off of their record. That's all, and I'll stand for questions. Unless Mr. Chairman wants me to wait until the conclusion.
Let's wait till the end. Thank you.
Thank you.
Next, Wesley McCain. And he is
Can you all hear
way.
me?
We can.
Great. Thank you, Mr. Chairman. My name is Wesley McCain. I'm acting COVID vaccination resources manager at the health department here in Wyandotte County. Hence my background. I'm at an old Kmart that we've repurposed for vaccines. here in the Midtown area. So, and I am here to testify in support of HB 2226. Thank the committee for testifying, and thank Representative Curtis for her tireless work with us on this issue. I'm going to tell a very brief story about how a local public health department where I work partnered with a local economic development agency to come work on this issue. I think it's a compelling one that I think sets the stage a little bit for why this is important for us. So in 2017, the local health department did an extensive community needs and priorities survey as a part of our 5-year health assessment. This included a community concern survey where we reached out and surveyed about 2,000 of our residents about their biggest concerns. One of the issues that emerged from that community concern survey, as well as from a lot of the economic and health data that we gathered as a part of the assessment, was a lack of access to living wage jobs for our residents. Lack of access to living wage jobs. So from a public health department's perspective, access to living wage work is related to increased household income. And increased household income is related to better health outcomes. So we were curious. So how on earth, you might ask, would a public health department begin to work on an issue like this one? We hire people, certainly at the health department, but we don't help other people hire people. So what's our role in this? Well, it turns out we weren't the only ones who were working on this issue. The Wyandotte Economic Development Council was already convening a workforce solutions committee. They were hearing in the community from employers who were having difficulty filling jobs in their county about a similar set of issues. So we heard about it from the resident side. We need access to living wage jobs. And they were hearing from employers who were saying, we have living wage jobs. Why aren't there more people who are applying for them? So we had an issue here to talk about and churn on. So so a partnership was formed. We were looking at the same issue and we started to work together on it. And worked and together published a jobs and education plan as a part of our 5-year community health improvement plan from 2018 to 2023. So in this process, an employment barrier got identified that we were curious about. And this is how it comes to this moment here. There were a lot of people who were eligible under current Kansas law to have their criminal records expunged, but who were not following through to get their records expunged. So a good sort of set that this state had decided, this is good. We want people to move on. We like clean slate. This is a good concept. But at the end of the process, or what was supposed to be the process, not many people were taking advantage of it. So that curiosity is what leads me here today to testify to this committee in support of HB 2226. I am not the most knowledgeable person in the room by far about the details of the expungement system. Others who are testifying in support are much more knowledgeable. But of all of the methods that I've researched to help remove this barrier for our residents, I believe that a thoughtful and careful implementation of automatic expungement in Kansas is the most efficient solution. Thank you for this opportunity to testify today.
Thank you. Next, Kendall Seal. Live and in person.
Thank you, Chairman, members of the committee. My name is Kendall Seal. I'm the Director of Advocacy for the ACLU of Kansas. We're a nonpartisan, nonprofit organization that works to preserve and strengthen the constitutional liberties of all Kansans. House Bill 2226 offers much needed and long overdue reform that will have tremendous benefit for people that have been touched by the criminal legal system by removing unnecessary barriers to reentry and allowing people a greater opportunity to thrive in Kansas. First, in our modern society, a criminal record can limit a person's opportunities, as we've heard from other witnesses here today. And those opportunities, right, they're not just limited 1 year or 2 year, they can be limited for decades after a person has completed their term. Even the existence of an arrest record with no conviction can limit job opportunities, housing, access to higher education, credit, and access to jobs that require professional licensing, which I know this body is already undertaking deep and thoughtful conversation around. That's one aspect with this bill we would suggest maybe an amendment. There are a number of areas for disclosure under this automatic expungement process. We would suggest that those disclosures not be required under the current statute. It's because of all the stigma and the loss of opportunity for people with a criminal record that the ACLU not only supports it, but we view this legislation as a critical tool for increasing public safety. This bill gets at some of the most important tools for fighting recidivism, access to good jobs, safe housing, and educational opportunities. Expungement works, and the benefits are far greater than any risks involved. Research study done by the University of Michigan Law School found that those who are able to obtain expungement have very little risk of recidivism and a significant improvement in their income and ability to secure stable employment. As a broader matter here, we need to expand and protect access to expungement. We also need to ensure that those who are eligible to clear their records don't have to stumble over even more roadblocks to make it happen. That's why this bill is so dynamic. One thing we would highlight for those that are not automatic expungement, we would recommend a removal of the financial barriers to expungement. To that end, we would like to remove the $176 docket fee and remove the Supreme Court's ability to impose fees up to $19 per application for those Kansans that do not meet the requirements for automatic expungement. We urge this committee to amend House Bill 2226 and remove the docket fee, and to pass this bill as an important early step to promote a more just criminal legal system. Thank you.
Thank you. Marilyn Harp.
Hi, thank you. I'm Marilyn Harp. I'm the Executive Director of Kansas Legal Services, and probably of the proponents, certainly the person who's done the most expungements. So Kansas Legal Services is involved in doing those and has been for the last 5 years or more, primarily out of our desire to see people successfully return to the workforce, and expungements are a huge barrier there. Getting out of poverty means getting a job, and sometimes that means getting an expungement. I've submitted my testimony, and I just want to highlight a couple of things for you. First of all, my expertise is in district court, those state court expungements. I can speak little about the municipal court side of this, although the law does cover both of those. Second, I want to point out that this bill is not about in any way who should get an expungement or who should not. That's been pretty well established in Kansas since 1978, and the scheme seems to be working fairly well. This proposal is about whether the paperwork process of dealing with those on an individual basis should end, or whether it should happen as a more systematic part of completing the paying a debt to society process that others have pointed out. And so let me point out a couple of numbers to you. In 2020, Kansas Legal Services represented 844 people in getting expungements. We had a request from about 1,100, but some of those people were not yet eligible. We had about 2,500 people look at our website, of which about 650 represented themselves to get an expungement with forms that we and the Judicial Council make available. So 3,500 people, we helped get an expungement. The problem with that is that in 2015, 5 years ago, so the people who would be potentially eligible for expungement, now 35,000 charges filed in district court. So we touched 1/10 of those with our resources. The KBI in their testimony make mention of about 2,000 expungements that were granted last year, or perhaps in 2019. Again, many people who are eligible for expungement are not getting there. And that's why some harnessing of technology to get those cases expunged instead of having our courts deal with them on a person by person by person basis with all that involves, needs to be pursued. And this law is this bill is a great proposal in that regard. I want to take my last 15 seconds to point out that Kansas Legal Services is right now involved in some research with the Access to Justice Labs at Harvard Law School to look at some of those very interesting questions about what happens with employment, what happens with housing stability for folks who get expunged. And by this time next year, we should have some good Kansas data on that. We're the only field site for this U.S. Department of Justice grant. And so our success in that regard is going to be taken statewide for other places. So I just might say that while Kansas has a difficult system for getting expungement, the Kansas law by many, compared to many other states, is quite expansive in who can qualify for expungement. So our data will be of interest to other states.
Committee, I have written proponent testimony, and it's been emailed to you from Aker Quinton, Barry Grisham, John Jinks, and Marcia Harrington. Anyone else as a proponent? Do not see any. We'll do question. Representative Samsel first, then Representative Humphreys.
Thank you, Mr. Chair. And looking over our list of proponents and opponents today, it looks like we've got an all-star lineup of very distinguished attorneys and others. I'm just curious if the groups have talked to one another, to use that dirty word compromise, to see if this is anywhere room for compromise. It appears a lot of the proponents, although not all, are from the Kansas City Wyandotte area. Is this a one-size-fits-all out of necessity because of constitutional or other issues? Are there other solutions that might work in some parts of Kansas that don't work in others? It appears that the Kansas district attorneys as a whole, or at least the organization, stands in opposition, and yet we've got very distinguished individual district attorneys who stand in support. So that's just my general question: is have these conversations taken place, or are we more at a loggerhead where Tom Brady's going to play Patrick Mahomes and it's winner take all?
That was a very painful reference for us. Well, I don't know who. That's probably a question that Marilyn, I think, is probably the best to answer. And I'm not even sure if I'm supposed to be speaking at this point or not, but that's who I would want to answer it.
Whoever would like.
Well, in terms of making something like this possible, it does require legislation, and legislation's going to require a statewide solution. I think the issue, the district attorney's testimony talks about two things. One, we don't have the resources to be the generator of all this paperwork. And I think that part of the solution may have some other technological solutions to it, rather than making the district attorneys the generator of the paperwork. The philosophical opposition to expungement, as put forward by prosecutors, is another issue, but not one that this is about. This doesn't propose to change that at all.
Good. Representative Humphreys.
Thank you.
Oh, go ahead, Representative Samsel. Do you have another one?
Oh, no, I construed that to mean it sounds like the two sides haven't talked yet, so not to continue a painful reference, but Tom Brady and Patrick Mahomes are perhaps not speaking together yet. And then the only reason I raise that is because it seems like the one size, I agree it's a Kansas solution, but does that mean like county by county? Like, I know when we shut down the state, that did not work very well for my 4 rural counties, but perhaps in other parts of the state it did. So I'm just, it sounds like we've got a problem or an issue and there's different solutions. So I'm just curious if those discussions have been had, and it sounds like maybe not yet. So thank you, Mr. Chair.
Come on up.
Thank you, Mr. Chairman. Representative, I want to say that I am a proud member of the Kansas District and County Attorneys Association, and we differ on this position. And so though we are a part of the same organization, we do believe that there are differences. And the arguments that are being made from the Counties District Association is not one that I agree with wholeheartedly. So I agree that that there has to be a statewide something done. Conversations have been held to the extent of are there different type of compromises? To the extent that you're talking, no, it has not. But there has been conversations, and I think to just kind of nip it in the bud, one of the main arguments that I think you run into with the traditional prosecutor versus the non-traditional, and I tend to be that non-traditional one, is whose job is it? It's not the prosecutor's job to help these folks get an expungement. And that is along where the issue comes, because in my book, it's not about whose job it is, but it's whose duty it is. And I think as a district attorney, it's our duty to try to make sure that everyone has the same opportunity, which then in turn makes the community safer. So I'll continue to have those talks with my dear colleagues across the wonderful state of Kansas, and maybe we can come up with a better solution. But I think it's important that paperwork should not stop us from moving forward and doing what's right and what I think our duty requires.
Representative Humphreys.
Thank you, Mr. Chairman. Just a couple, I think, quick questions. Just a clarification. It's 3 years after the sentence is satisfied. Okay. No,
3 years for misdemeanors and lower level felonies, 5 years for the other felonies, and then there's a whole array of felonies that cannot be expunged.
right. And that's the same as they are now?
Yes.
Yeah.
Absolutely.
Okay.
Yeah, this doesn't touch expungement at all. It's really the process.
Okay. And then, I think this is for Mr. Dupree. It's not Mr. I mean, it's Mr., but DA. Yeah. So you had mentioned that, that couple didn't know that he could have his records expunged, but how would they know now? So what's the mechanism to let them know that their records have been expunged? Because you could be letting people know now.
And to answer that, and because I've seen a couple people up here, pardon me, I'm just wiping all that. So my wife said I better come home healthy. And
Tell
so
your wife hi for me, by the way.
I will tell
Okay,
her hi.
all right.
She allowed me to leave the house today. I'm so grateful. So they know now, in part because of the judicial system in whatever county you're in. For instance, in Wyandotte County, we, when we're doing our expungement fair, we let it be known, we put out ads, we get on social media and so on and so forth. Beyond that, they don't know. Now, and I'll tell you that before I was the district attorney for about a decade, I was the defense lawyer in the state of Kansas. And with that in mind, I did expungements for citizens. The citizens that came to me had to pay anywhere from $400 to $1,000. And the only ones who came were the ones who were educated to the process and had the funds. I think it's important to note that the average person who has had a crime and who has been incarcerated make less than $15,000 a year. Only 13% of those folks make more than $15,000. When you put the income and the education in viewpoint, there's going to be a lack of knowledge, and they won't know that. And so I think this really evens the playing field, if you will, and gives individuals who may not have the funds and individuals who are uneducated of the process to be able to have an opportunity that they didn't know, like that gentleman, he in fact had.
Yeah, and I'm not questioning the validity or the, I mean, I've worked with Kansas Legal Services some too. But my question more was, how are you going to let them know? Isn't that another burden? Which kind of, my next question is super similar, is when I look at the fiscal note, Chairman, it says 8 FTs for the KBI. But I'm thinking there's a whole nother level of administrative costs for the districts and for everyone else too. So I'm just trying to think how, as a fiscal note, do y'all think the fiscal note is accurate, or how, what other positions? So letting them know, and then what other positions, like for your department, would you need?
So on our part, I believe, and I'll allow Representative Curtis to talk more about that, but on our part, the way that the process is set up, when an individual is convicted of a crime, and this is every crime that ever happens, the judge at the sentencing says, by law, they must say that you will or can be eligible for expungement, consult a lawyer to determine that. That's their way of knowing by information, by way of sentencing. Now, do I think that that seals the deal? No, because I think we still have an educational problem. However, I think from our point of view, we simply need to add a line in there at the sentencing concerning the automatic expungement, that this case will be automatically expunged or has the ability for automatic expungement at whatever time it is. And I think that that doesn't add any financial burden on the district attorney's office, because the court simply adds a line. And then concerning the paperwork, as I indicated earlier, when a person is done with their probation, our office has to file the appropriate paperwork and order for that person to be off of paper, right? This is simply another process that we then file another piece of paper to deal with that. I'm sure that Maryland and others would have more information and more education to the community, but by way of the district attorney's office, I do not believe that it is more work than what we are already doing.
Thank you, Mr. Chairman.
We have Representative Ralph, then Carmichael, then Wheeler. So that's my list at this point in time. Representative Ralph.
A couple of questions, Mr. Chairman, if I could. And just for whoever ends up answering these, I'm coming from a municipal standpoint, and my municipal prosecutor back home, and when I read what I did of this, I panicked. So that's where my questions are coming from, but I've got two right now, and they're basically procedural. A couple of years ago, we were reviewing our cases and our load, found out that in our history, we've got way more out-of-state defendants through our municipal court than I ever would have imagined. Procedurally, okay, we roll up on 3 years. I've got to file a petition on an out-of-state defendant that even at the time I knew they were from New York, and now 3 years later, I've literally got no idea where they're at. Procedurally, what occurs there after I file that petition?
Representative Ralph, I guess how I conceive of this is an entirely, I mean, there's a piece of paper, and how we do expungements now and how you're familiar with them is file a piece of paper and a petition in the court. And I guess where we hope we're going is a process that just seals it. That just at 3 years, maybe there's a judge signature on it. Maybe the law just says that the clerk seals the record at 3 years, and we don't have paperwork and we don't have a petition. I get where the law says right now the DA file initiates that process, but all those concepts about, I mean, there are some victim notification concepts that we got to figure out. But ultimately, what happens in this whole process is the KBI gets a piece of paper and says, seal it. And then they tell NCIC, seal it. And that's what happens.
Procedurally, in my city, when we file that petition on an out-of-state defendant that I don't know where they're at, what's this bill say happens?
You send a copy to the last known address.
And they don't have to be involved then?
No. It's sealed.
That's what I need to know.
Yeah.
Second question, if I can. My frequent visitor to municipal court that has 1 or 2 charges a year.
Right.
Is this a rolling process then every year that oh, look, John has his 3 year ago cases to be expunged. And next year I'm going to roll 2 more off, and the year after.
And those other ones can still be used in his sentencing, because that's one, I mean, I believe that is still, those are still available.
I am going to have to file one every year going through for John if he's rolling through with charges every year.
I would acknowledge that, yes, that is the situation, and yet there's 100 not Johns, who get the benefit of this.
Thank you, Mr. Chair. That's what I need. Representative Carmichael.
Thank you, Mr. Chairman. Ms. Harp, do not go far. I have questions for you this afternoon. Welcome back. I listened with care to my colleague from Wellsville's questions about, is this just a Wyandotte County problem? And questions about whether or not anybody's ever talked to anybody else about this. And maybe even questions about why so many of our conferees today come from Northeast Kansas. But of course, your organization represents people all over the state, does it not?
It does.
And the problem with only a comparatively select few obtaining expungements, while 10 times as many may be eligible, in your experience, is that confined to Wyandotte, Shawnee, Douglas, maybe even Johnson County, or is that a statewide phenomenon?
You know, thanks to the efforts that District Attorney Dupree's done, it's less of a problem in Wyandotte County than it is anywhere else. You know, their annual expungement fare has made a difference there. So no, it is very much a statewide problem of access, of people hearing about it.
Well, I know in my county and amongst my constituents that we've talked our ears off, so to speak, about this. I mean, we've talked about it every year that I've been in this legislature. What can we do to streamline the expungement process and make sure that it's not just the haves, the have councils, the have money, but it's also the have-nots that get these expungements. And is this a new idea that just cropped up this month, or to your experience, have we been trying to figure out how to fix this for many years?
Well, there are a number of states who've gone ahead of us and tried automatic expungement. I mean, nobody's repealed it. Having tried it, it's been a positive outcome. Pennsylvania was the first. And there are now about a dozen states who have tried it successfully. So Kansas is getting in line about that.
And sorry, sir. I was going to add that you are correct that it is fairly recent. I think Pennsylvania passed their expungement law in 2017 or something, or 2018. So it is a fairly recent wave that states are on. So it's not something that's been around, this idea. And if I could be wrong, Marilyn, but I believe there is technology that is available to states now, which was not available to states 10 years ago or 20 years ago, which allows court record databases and police record databases and district attorney databases to process this in a way where I do not know the extent of this technology in Kansas all the way, and I wish I did, would allow this to be a win-win-win work-wise for everybody involved. And that is something that I would be very curious about in this, and I apologize. That's my question, but yes, to answer your question, it is a fairly new thing.
Okay, Mr. Chairman, to wrap up, knowing that Representative Wheeler has good questions, I would have to testify that it's not a new thing at all in my experience. And we've had these ongoing discussions for literally years and nothing seems to get done. But Ms. Harp, as you may know, in Sedgwick County, where you, I think initially, maybe at one time you were a member of our bar association, but we put out the call every year, once or twice a year, for lawyers to volunteer their time, and we all come down and we try to expunge people, and we usually end up with more people in line than we have time to take care of the problem. Meanwhile, private lawyers are charging between $500 to $2,000 a pop to do these things. From your perspective, would it be better to just say if the state can afford to convict them, the state can afford to expunge them?
That would be my bottom line. The other thing I'd point out is that, you know, the KBI's cost estimate assumed, I guess, that 1 million things would happen all at once. which is probably unrealistic. And even if it did, it's a one-year expense, because then it all happens, and they don't need 8 people a year every year to do that. There might be a big bunch at once. So I kind of had a question about their cost.
I appreciate that. And Mr. Chairman, I appreciate your indulgence. I hope the KBI will look for an efficient way to do this, because my experience has been that it's one piece of paper filed here, another piece of paper filed there, the wrong stamp here. And it might be better if we just had a uniform way and just got it done. Thank you.
Representative Wheeler.
Thank you, Mr. Chairman. My questions are for Mr. Dupree. Mr. Dupree, welcome from the world of criminal defense to the world of prosecution.
Thank you so much. Took me a little bit to get acclimated, but I'm here.
Well, I tell you, I join you in that. 24 years as rather high-level criminal defense and 20 years as Finney County Attorney full-time prosecutor.
Well, thank you for all of your years of service, sir.
So I have some questions for you, if I may.
Please.
Made a few, Mr. Chairman. This automatic expungement, you as the district attorney are the chief law enforcement official of Wyandotte County. Is that correct?
Yes, sir.
And you are charged with upholding the law in Wyandotte County and protecting the peace and dignity of the people of Wyandotte County.
Yes, sir.
Now, knowing that, and knowing that you are dealing with a person, you're in the district court, before you get this automatic expungement, sir, are you going to check the criminal record of that person?
Yes, sir.
Do you run an NCIC on each one?
You run one on each one, or in the alternative, just make sure in other means you check their criminal history.
Alternative to NCIC?
Well, just in case. So what we do is we run the NCIC, but we also look at other databases, and likewise, if they have a hometown, some folks, some offices fail to put stuff into the computer. So we try to double down in making sure that folks' history are.
If you come across after 3 years for automatic expungement of a conviction in your court that is qualified, and you find that the person is sitting in prison in Indiana for sex trafficking out of Finney County, are you going to give him an expungement, sir?
No, sir. You do not, and I thank you for raising that question. As I looked at my cell phone, I was texting when you called me up to confirm the answer. I just felt it coming. By statute now, if an individual has a conviction of a slew of crimes in between the point of conviction that they are looking at getting expunged and the time of expungement, that conviction does not allow them via statute to be eligible for the expungement. And so by statute, kind of going back to what Marilyn indicated, we're not arguing that the qualifications for expungement be changed in any way. Your example falls right into that, the statutory requirement. It prohibits an expungement. It prohibits a judge from saying so, and thus it would prohibit us from putting that forward. The 3 to 5 years is one thing, but then in between that 3 to 5 years, the question comes, was there any other convictions and or arrest? And if so, were any of those ones that prohibit via statute them from getting that expungement? So no, sir.
And that takes human intervention, and it also takes judgment on the part of the prosecutor, correct?
Yes, sir.
So it's not really automatic, is it?
It's going to have to happen either way. So right now, individuals who apply for expungement right now, we still have to look at it, review it, talk to the victims. And so nothing changes in concern of our roles and our responsibility. In essence, the only thing that will happen is that people now will be exposed to the reality that this is for all. And thus our duty to do as we have been doing may be amplified, but it is nothing changing for our duties.
And I appreciate the fine purpose that you intend. I really do. But I have another question.
Please.
When you ran that NCIC, you were representing the people of the state of Kansas to ensure their safety. Is that correct?
Yes.
And you don't find anything that disqualifies?
Right.
Assuming that.
In this example, yes.
In this example. But you were representing the people of the state of Kansas and running that background check.
Yes, sir.
And now you're going to turn around pro bono on behalf of yourself only to run a motion to expunge a conviction representing a defendant who otherwise may have been represented by counsel. Would you explain to me the ramifications under the Code of Professional Responsibility of that kind of conduct, representing multiple parties in a conflict?
I don't want to
Done.
talk you. I didn't want to interrupt you. So when we say representation of individuals, when we're talking about the code of conduct, absolutely, I cannot represent a defendant as a defense lawyer if I'm the prosecutor. We both know that. But I think it's important that we all have kind of a reality check here. And that reality check is that as elected officials, we are not simply representing the individuals that we like. We're not simply representing the individuals that are the victims of crime. But as an elected district attorney, as the chief law enforcement officer in my county official, it is upon me to represent both the convicted and the non-convicted, the ones I like, the ones I disagree with, the ones with convictions on their record, the ones without convictions on the record, the ones that need a job, the ones that have a job, the ones that need an expungement, and the ones that don't. And so I'm going to kind of pull away and kind of reject what the corner you were trying to put me in, because as a representative of the county, it is my responsibility to make sure that the law is given fair access and just access to all people that I represent, and that includes folks with criminal records. And I think the law is clear that as long as victims are notified and they have the opportunity to be heard, that's heard. But the law is also clear that once an individual has paid their debt to society, and unless we are going to change the law to say that an individual needs to have a criminal record for the rest of their life, despite them going to prison and or doing their probation in time, for them to pay their debt to society, we then need to uphold the law that we say is there. And that is, when they have completed their sentence, then they should be allowed to have it expunged. And as the prosecutor, that correlates with them being able to get gainful employment and getting a job, and thus not going back to that criminal life. And so I think that it's not a problem at all, and it's no ethical issue when I am doing what the law says that I can do.
As was suggested earlier, a person wants their expungement completed, they go into a lawyer who may charge $500 to a couple $1,000s. The reason why is because that lawyer is representing that client. And I don't care about how much good intention that you intend when you undertake to represent the state and the criminal defendant at the same time. You are in violation of the Code of Responsibility. That concerns. Now, can you find another way other than using a prosecutor to switch sides and go the other direction? Another way to do this?
Representative Willer, I think that there's always room for conversation and to figure things out. Again, I'm going to reject and disagree with your analysis and your standpoint. I think that as a prosecutor and our oath, our job is to pursue justice and safety for our community. And we represent everyone, period. That's hands down. Right now, what we have is the haves and the have-nots. We have the rich versus the poor. Black, brown, and broke folks are the ones who are not getting expungements because they're not able to financially, and or they don't have the education to know that it exists. And for us as elected officials to pretend as though that is not a reality for over 70% of the folks who enter into the criminal justice system and simply say it's someone else's responsibility. I would absolutely agree with the representative or whomever it was on the screen that if the state has the duty and the ability to convict them when they have served their debt and paid their debt to society, then we should have the same ability to make sure that they're able to move on.
Let's just say we disagree on the ethics issue. I respect your position.
And I would not have want to go against you in court.
And I appreciate the fact that you say we should have the ability, but remember there are rules. And those rules from the Supreme Court are very real. And your duty is to seek justice. It's not to do good for all of the people of Wyandotte County, even those you oppose. And it's good to meet you, sir. I hope one day your wife will let you shake my hand.
It's going to happen. Have a good one. Thank you.
Okay, committee, no, oh, wait a minute. Representative Carmichael, final question.
Suffice to say, I just simply cannot agree with my learned colleague from Garden City. Thank you, Mr. Chair.
Okay, we're going to move on to opponents. Oh, no, neutral conferees. We have one. It's written from the KVI, Leslie Moore. Anyone else as a neutral conferee? Do not see any. Let's move on to opponents. First up is Todd Thompson. Todd is on WebEx.
Thank you, Chairman. Can you hear me?
Yes.
Thank you. I guess I sit here before you representing not only the Kansas County and District Attorneys Association, but I'm also the Leavenworth County Attorney. To give a little background, I actually was one of the first people in the state to do an expungement day. In fact, Mr. Dupree contacted me when we did one of these. As Mr. Wheeler was suggested, when we did our expungement day, we had to make sure that we had defense counsel or opposing counsel, or the person handled the expungement pro se, as our office would not have a conflict, due to the fact that we needed to be able to review over the criminal history and whether they applied. In this bill, I think we had talked about it multiple times. I myself, and I think my colleagues at the Kansas County District Attorneys Association all agree that expungements are beneficial, especially for those to be able to move on and move past. I can tell you one of the differences between Mr. Dupree and I's expungement days or festivals, whichever one you would do. Mine expanded almost 3 months, where Mr. Dupree has a day or a period of time. I can tell you over that 3-month period of time that I was doing the expungement day within my office, it dragged and bogged down almost everything we were doing with the rest of our work. It was rather expansive an amount of energy and time and effort it took upon my staff and my attorneys to assure people were getting processed properly. To imagine to be doing this for the litany of cases that they're hoping to just do an expungement, I'd imagine it would be an incredible financial burden on not only on every office in the state. It would probably smaller counties wouldn't see as much, but I know my office being a medium size, I would need extra resources just to handle that process. I know that is something that had been discussed about maybe finding other ways to do it, but I can tell you right now, the way this bill is written, that would be an incredible burden. Some of the other things I want to address about the procedure, just like Mr. Dupree, I had several people who came up and received expungement, and when they did so, they were overjoyed. They were blessed. They cried, and I can think of one 80-year-old man who wanted to have an expungement for 30 years and finally was able and came in and did it. It was a true reward, and one of the biggest rewards he found out of it was he did it himself. It was an accomplishment. It wasn't just a task. They took that certificate and framed it in their house like they would have framed a diploma or a degree or an award they would have had. It was something that they had really earned. That's something about doing these expungements that just blanketly handing out to every single person is overlooked. We're overlooking the crime that actually occurred by just saying now you are clean slate, you are free of this crime. They not only have time that they have to expand, but they need to show that they want this and put forward the process. I note that, as Mr. Dupree testified to, every single person is notified after their conviction of whether they have a right to expungement or not of their crime. It's notified when they do it within court, and they are told. I feel like it's an insult when, and I'm sorry, Mr. Dupree, because you are a good friend, but I think it's an insult when you say the poor don't have enough education to understand how to do one. I can tell you that we've had several people who are impoverished be able to do the expungement forms. And Ms. Hart, I greatly appreciate the website that KLS has, because we utilize and provide that for them in the paperwork, and they come in, they fill it out, and they're able to do it themselves. Like I said, this is a significant accomplishment for people that we're just overlooking the fact by doing that. As testified by the ACLU, and I'm sorry, I don't know if I wrote down your name. I believe, I'm sorry, I don't have your name. But in doing this, talking about having the payment and everything, costs, fees, and everything like that waived, that already exists. There's a financial affidavit, and they're able to fill out that affidavit and have every bit of the cost. That mechanism already exists, and I don't know why we're having to repeat the burden again, unless we're trying to say we don't believe in the people know how to do it, which again, I find that to be rather insulting. Further, in going through it, one of the things that the statute also considers is consistent with public welfare. This bill, as written, as proposed, gives an automatic expungement. It ignores the fact about this, at least from my review, because it's a part of H, the consideration of public welfare. As Mr. Dupree had discussed, that when they do their expungement, they contact if there's any victims. And he kind of said, like, most of the time the victims don't care or don't show up. I can tell you I have 2 misdemeanor cases of vehicular homicide, and I have hearings next week solely because the family wants to come and share their memories of their deceased and argue that the people who killed their family member are entitled and allowed to get an expungement. I've had several domestic batteries and aggravated batteries of low level request to have expungements, and there's nothing more heart-wrenching than having to tell them, this is not even part of that expungement because it happens automatic. They don't even get that opportunity to argue, to present why they're still hurting. I agree that for the people, they deserve to have an expungement. They deserve to move on. It helps them with housing. It helps them with education. It helps them with getting better jobs. It is so fundamental for any person who has a conviction to be able to move on. But when we have crimes, we cannot forget about our victims. We have to remember them, and protect our community and give them a voice. And this is just nullifying that. And, with that, I stand for any questions.
Thank you. Next, we have Britton Stites.
Good evening, Chair. I'm Britton Stites, and thank you for allowing me to testify. I'm the city attorney for Junction City. And I came into this, and I both am city attorney and the chief city prosecutor. Therefore, I both take on the civil and the criminal responsibilities for that city of the first class. I'm going to touch on a few things that are, I think, unique more to the municipalities. Is we have, as a whole, more limited and smaller staffs as well as budgets. So what we're looking at here is in section 1 of the proposed bill, it says that any violation of a city ordinance unless otherwise not eligible. So what we have here is practically every crime of traffic infractions, tobacco infractions is included in this. The city of Junction City has approximately 8,900 cases generated just last year. So what we're looking at here is we have 3 court clerks, 1 full-time attorney, 1 legal assistant, and then 1 part-time contracted attorney. That put an impact on the court to add 1 or 2 more positions there, as well as it would put an impact on my office, the legal department, to have more people there. As a part of this hearing today, I'm preparing both for an eminent domain taking later this week, as well as other duties involving economic development. So I'm running basically general practice here on behalf of the city, on top of needing to review these crimes. They have occurred. Whether or not people are eligible or not, I still need to review them. Because as Wheeler and Dupree talked about earlier, I do have a duty to ensure justice is done for my community. And what does that mean? Does it mean for the individual? Does it mean for them as a whole? What it means is it's justice is to be done. So for that, I need to be able to focus on every single one of those cases that comes up for review. And I have to agree that it is an ethical quandary. In dealing with these issues, if I help somebody and file it on their behalf, even though it's filed in that case, I'm still filing on behalf for their expungement. Now, I can, as a prosecutor, sit back and review, run the NCIC, and evaluate that, as well as other factors I have at my disposal. But I still run into the issue that I cannot do it on behalf of them. I do it on behalf of the community. And that's where there's an ethical issue. One thing I do know in other places is Michigan, just back in October of last year, they passed a clean slate package, which is an automatic expungements. But what they did make sure to do is that certain offenses, such as DUI and domestic violence, are not allowed automatic expungements. As written, HB 2226 would allow automatic expungements for domestic battery, theft, DUI, which are, in my jurisdiction, are the serious offenses. So what we're looking at here is I need to notify the victims in all those cases, animal cruelty, whatnot, and still have to fill my duties both as a prosecutor as well as my victims' rights notifications. I do agree this is a good conversation to have, but I think as implemented in here, needs a lot of refinement. I second the representative earlier that talked about maybe having a conversation, having previously had the joy that can be a judicial council. That might not be a bad idea here. I'm definitely not volunteering for this one, this go around, after dealing with service animals and assistance animals. But I think what we should look at is those expungement days are great, but when I've got a single attorney and in a small city where everybody recognizes me, it runs a little bit different than when you have a full staff in Wyandotte County. What I see is maybe a shift on actually clarifying what the burden is to bring before the court, actually clarify what that is, clarify what kind of evidence can be brought. I think if you look towards departure motions and what evidence is allowed there, may I simplify some of this as well, because that way people can make their statements, have their briefs, and those be treated as the equivalent of evidence. Or maybe even put a restriction on prosecutors that they can't oppose it unless they can articulate probable cause as to why it should be denied. And for that, I stand for questions.
Next, Amanda Stanley.
A lot taller than I am. Thank you, Mr. Chairman, for allowing me to present testimony today in opposition to House Bill 2226. As a lot of the other conferees have talked about, this bill, while it purports to create automatic expungements, the process is not automatic. And I'm focusing just on the municipal court piece. I'll let the district attorneys fight amongst themselves about that piece. But with the municipal court piece, at least, this does shift all the responsibilities onto the city, resulting in a pretty massive unfunded mandate. Our municipal courts vary vastly across the state of Kansas. I've had the privilege of serving on a best practices committee for municipal courts, which was a year of my life I will never get back. But what it emphasized to me is how different our municipal courts are. We have a municipal court that meets for 2 hours, 5 days a week. We have municipal courts that meet 1 day a week. They operate on part-time prosecutors and part-time municipal court judges. So what this bill does, and I will admit, I've read it like 15 times now at this point, and I'm a little confused about some of the pieces of it. What this bill does is it shifts that filing of the petition onto the prosecutor. But at least for the municipal court piece, it does change the process of who gets expungements. Under the way this bill is written, it says any municipal court violation can be expunged after 3 years. It doesn't make any provision for not granting the expungement if there are additional crimes afterwards, or if you have a pattern of criminality. There doesn't appear to be any mechanism for victim notification. And while we often think of municipal courts as your traffic courts, they deal with a whole lot more than that. They are your courts that can handle any kind of misdemeanors. These include things like sexual battery and domestic battery and criminal trespass and theft and a whole lot of other things that I included in my testimony. But there are a lot of serious crimes. And the way this bill is written, at 3 years, it says the prosecutor shall file the petition and the judge shall grant it period. It doesn't talk about running a criminal history. It doesn't talk about notifying victims. And I think those are all pieces that really need to be worked out. And if we're going to include municipal courts in this kind of legislation, then let's include municipal courts in the process, in the dialogue. Cities do participate in clean slate days. And when I sent this out to our municipal court judges and our city attorneys, I got pretty rapid feedback back. There are lots of people interested in this dialogue. Lots and lots of them volunteered to be part of committees to study this issue, but they highly suggested that while expungements are a wonderful goal and that there are possibly ways to make it easier by waiving of filing fees, making simplified forms, making it easier for people to file expungements, that this legislation is not the right mechanism for municipal courts at least, and we would urge you to carefully consider a better mechanism and include municipal court judges and city attorneys from all sizes of cities in the dialogue and the process. Thank you.
Thank you. Sean I'm awful with names. Sean DeJarnett?
You
Something
got it.
like that? Oh, did
You
I?
got it right.
Wow.
I've been
Okay,
called a
good.
lot of things, and that's probably one of the better ones. So I come before you, and I appreciate the opportunity to speak from the even smaller municipal courts. I have been practicing law over 27 years. Primarily of those 27 years, I was a criminal defense attorney, so I've done a lot of expungements. But the last few years, I'm a municipal court prosecutor, part-time in Wellington and part-time in Derby. And I am the only municipal court prosecutor in those two communities. I'm also the municipal court judge in Caldwell and Belle Plaine, so even smaller. I've got to agree with the comments Amanda made regarding the unfunded mandates. In those offices, I'm required, I read this to require me to file the motions. I do see the ethical quandary that may pose, especially when somebody may have more pending matters that aren't eligible for expungement, or they're back in front of me with a shoplifting. But I see a bigger problem, maybe even for the much smaller municipal courts such as Caldwell and Belle Plaine. Those rural communities struggle to find people willing to be municipal court prosecutors. Typically, they work maybe 1 to 2 hours per month for those communities on an hourly rate. They handle tickets written by officers, but that can include misdemeanors as well as infractions referenced before. To require those prosecutors to spend the time to file an expungement is creating a tremendous burden on those communities. I fear, and I've talked to both of my prosecutors regarding this bill, that we will lose prosecutors and we will lose our courts. And for a lot of those smaller communities, that is one of the identities that they have. In Wellington, I also work part-time based on about 5 to 10 hours a week. Again, caseloads are much higher than in my smaller municipal courts, but I don't see how a part-time prosecutor would be able to keep up with the mandate to automatically file these. And in Derby, obviously, I spend about 20 hours a week. I have one whole court day every week, and then the rest of the time is preparing for courts, trials, and advising law enforcement. I will touch on Representative Wheeler's ethical concern briefly, especially as it relates to municipal courts, because as I see this, as Ms. Stanley touched on, these are automatic. I do see a lot of repeat offenders. I do know that we typically wouldn't have expunged those, but again, this says shall. So it, as I read it, creates a possibility of me having to file a motion to expunge an offense that happened in the past, 4 to 5 years ago, after they have done their probation. And they may have pending matters of a similar nature in front of the court. That's going to create an ethical issue. I'm prosecuting them in one case and expunging them in another. I understand those expungements wipe it clean for employment purposes. I think we all agree of the importance of a clean record and the enhancement of employment. Again, having been a defense attorney, 99% of the people wanting an expungement was for that purpose, whether it be to obtain a job or to obtain a promotion or something of that nature. The problem may become with the unfunded mandate is throwing that burden on the prosecutor rather than asking the criminal defendant to have some responsibility to approach the court. I think the problem is twofold from listening. One is educating the defendants about the eligibility for an expungement. I will speak to that. I think the courts are doing a much better job. There was case law a number of years ago requiring the courts to advise of an expungement. I think we could educate them at the time their sentence is satisfied that they would be eligible in the requisite number of years. I think making forms available would make all of those things easier. The financial component with forms would eliminate the attorney's fees. And obviously, the bill does address the filing fee side of that. But I think those things would help accomplish that, but still make the defendant have a little bit of ownership or a little bit of responsibility in approaching the court, as well as eliminate a prosecutor having to file a motion for expungement that benefits the defendant, but maybe not the community that the attorney represents. And I would stand for questions.
Thank you. Committee, next up was supposed to be Melissa Rundas, but I think Melissa is no longer online with us. So she's going to be written opponent testimony. You also have written opponent testimony from City of Olathe, City of Westwood Hills, Hiawatha City Attorney and Municipal Prosecutor for Frontenac and Girard, Hiawatha Municipal Judge, another from the Kansas County District Attorneys Association, Sheriff Easter on behalf of Sheriff Sedgwick County, the Kansas Sheriff Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officer Association, and the presiding judge from the city of Overland Park. Anyone else as an opponent online or in person? Okay, questions, committee. Originally, I had Representative Carmichael, but he's shaking his head and his hand is down. Representative Jennings.
Yeah, more of a, maybe a comment more than anything. You know, we just passed a bill last week over to the Senate to reconstitute and continue the Criminal Justice Reform Commission. And one of the elements that they are tasked with, should that become law, was eliminating, effectively finding a path for elimination of diversion agreements, expungement, if you will, without much process, I think is what they're looking at, that probably just a time factor would lapse and it would be sealed. I have sent a text to Mr. Bennett to see whether or not he feels that might be an area that they could undertake during this next year to maybe dig into this a little more deeply and maybe come up with some solutions. They have a cross-section of people, system and otherwise, that might be able to review it as an alternative to the Judicial Council, which I would guess otherwise this might be going to visit. So just a thought.
Not to give anything away, but yes, Representative Curtis and I have visited about this. This is just a good opportunity for everyone to have the opportunity to present the pros and cons. What issues do we need to work through? And then we're going to try to figure out what that next step is. So that's a good thing to think about. Representative Samsel.
Thank you, Mr. Chair. I'll make it quick. I know, I don't know, but I'll suspect the chairman's got KU plans tonight, get to a game, at least on TV, I hope. But
I have a school board meeting at 6 o'clock, so I get to go to school board tonight.
I didn't even know KU had a team.
Yeah, I know.
But my only, much similar to what Representative King said, perhaps, but to me, we talk about transparency all the time and running for politics and everything else, and I think most agree transparency is a good thing. So perhaps rather than putting things on people's records and then expunging and that whole process and the cost and everything that comes with it, is there a way to perhaps, I don't know if lessen is the right word, or deal with the consequences of what goes on the record so that having it on the record is perhaps not as, I don't know, I guess penal as perhaps it seems like it might be. So wherever this thing goes from here, that's just the one thought that I've had from start to finish. So thank you, Mr. Chair, and rock chalk.
Any other questions? Representative Curtis.
Thank you, Mr. Chairman. I just want to say thank you for the robust discussion today. Definitely have been working with the coalition in Wyandotte County, on talking about the benefits and then definitely some of the challenges that have come up today. So I just hope, I think I've heard from most of the opponents that in principle, they're not necessarily against looking at streamlining the process and having some type of auto expungement for certain crimes. So I just hope that all of them would be agreeable to working with however that coalition goes forward and however this discussion continues. So I hope that they'll be willing to have that commitment to continuing the dialogue with us.
Very good. Thank you for your work on this. Any other questions for the Opponents? Seeing none, we'll close the hearing on House Bill 2226. Before we adjourn committee, I will recognize Representative Burris.
Thank you, Mr. Chairman. Can you hear me okay?
I can, yes.
Mr. Chairman, I apologize for the inconvenience. I was hoping to respectfully withdraw my bill introduction request from earlier.
Is there any objection to withdrawing Representative Burris's bill introduction request? Seeing none, we will withdraw that and not get that bill introduced. Thank you, sir. Okay, committee, have a good evening. Go Jayhawks. We'll see you tomorrow.